Welcome to today's immigration tidbit. So, today I'd like to talk a bit about employment based visas. When someone from another country or they made it to the US and whatever, or in the US, they many times think that the only thing that they can do to ultimately get the green card is to marry a U.S. citizen or to wait 25 years for, a sibling, their petition to become current. When in fact, that is not the case. There is a whole world of employment-based petitions out there. And if you understand the basics of it, then it does two things. It opens up the door for a bunch of different kinds of petitions you might be able to do. And it makes it so you don't do anything illegal, okay? It just befuddles me how many people that I have to do things for that paid $10,000, to have some coyote run them across the border or to do something illegally when they could have fully qualified for some employment-based petition. So as long as you know that such petitions exist, and as long as you have a basic background of what there is, then it will make it so it's much less likely that you're going to overstay or do things that might get you in trouble later down the line. So let's talk about the different kinds of employment-based visas and the preferences. Now, as we talk about it, just like with family preferences, there's different preferences of employment. Okay, so if you look on the family side of it, there's F1, F2, F3, F4, and so forth. F standing for family. Well, for employment, okay, it is referred to as EB. Okay, when you look in the visa priority chart and you're going to see a big table, it's going to have those initials EB. That's employment based. Okay, and there's EB1, EB2, EB3, EB4, and EB5. Okay, so there's lots of different employment-based visas, and there are divisions in each one of those. Not everyone, but there's a lot of divisions in several of those that have different categories, but are still under the main subheading. So let's talk about EB1s first, okay? Now, EB1s are the cream of the crop. Those are the hardest to get. Those are the most difficult, but they are pretty much the best, okay? And we could stick EB5 in there, but we'll talk about that later. So EB1s are for those very accomplished people in different areas that would qualify for an EB1. And if so, then they can jump and get the green card relatively quickly compared to many other kinds of petitions. In fact, I don't think I've ever seen a backlog on EB1 petitions. And by backlog, for example, let's talk about India. Let's talk about, EB2s, people with master's degrees. They're waiting up to 15 years for their visas to become current. Can you imagine going that many years to school and having to wait that long? So, if there's a way of getting an EB1, you want it. But honestly, let's be honest here, of every 1,000 people, maybe 10 of them would qualify for an EB1, okay? But if you are in that little group, then that's where you should go. And just so you know, a lot of people think they can't do two different petitions at the same time. I mean, you can do a regular employment petition, but also try for the EB1 just in case. All right. So let's break down the EB1. There's the EB1A, the EB1CB, and the EB1C. So what are they? So the EB1A is for extraordinary alien petitions, okay? Those are people who are at the top of their field, and there's all kinds of awards and things that they have. All right? Now, I have people come to me that they look at this EB1A list. I mean, it's in the law. It says you need at least 3 of this list of 10, okay? Unless you have a Nobel Prize. If you have a Nobel Prize, you're in, okay? But generally, people who have Nobel Prizes don't walk in the door and ask you to do an EB1A. So for 99.999%, they need to have at least 3 of the 10 items listed. We're talking publications, high remuneration, things like that. And I have people who they say, okay, I have 3 of them easy. Boom, 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 right? And they go, where's my EB1A green card? And it doesn't work like that. That's the starting point. Okay, getting 3 of them is the starting point. And the EB1A is very discretionary. I'm not kidding. Every EB1A I've done, it's at least that thick. And it's not just blowing steam that thick. It's real qualification arguments, that try to get in. So that's the EB1A. You don't need a petitioner, okay? You basically just state you're going to continue in the same field, and you self-petition under the EB1A. So that's a good option for those people that qualify. Now, the next one is the EB1B, okay? Those are outstanding professors and researchers. And there you should have a university, of course, that wants you in a tenured position. And assuming that that's the case, you jump right into that category. Next is for business people, okay? If you have a company overseas and you buy or own a company in the US and you manage both, you are a multinational manager, okay? So the EB1C is for the multinational manager visa, and that one is an excellent one for entrepreneurs and people who like doing business and running the show, okay? And that's actually open to quite a few people that have no idea about it. In fact, with this one, I have a lot of people who say, well, I don't know if I have $1 million to invest in the EB5, and I don't know if it's going to work. And I know it's going to take a lot of years, and it's a conditional green card. But with the EB1C, no $1 million needed, and it's not conditional. Once you get the green card with the EB1C, you're in, okay? That is the EB1 category. So those are the 3 divisions, and we go from there. Now, the EB2 category is where most people who want employment petitions go. So again, if we're talking in this case, of 100 people applying for employment petitions, probably 80 of them, okay, probably 80 of them to 90 of them will fall within the EB2 category, okay? Now, the EB2 category is divided into different areas as well, okay? And that is where it's important to distinguish, because here you are talking about visa backlogs and priority dates. And when you look at the EB2 category, it's basically divided into different types. The EB2, okay, are basically people who have advanced degrees or are exceptional ability. Now, I know these are just words here, but exceptional ability falls under EB2. Extraordinary ability falls under EB1, okay? Clearly, EB1 is harder and better, but if you can't get that, you might try the exceptional ability under EB2. Now, if you do have a master's degree or higher, and the job requires it, then you would do the EB2. So again, it has to be the job requires it. So for example, if you're going to work as a secretary because the job is open, but you have a master's degree in engineering, you cannot say that that secretary needs a master's degree in engineering and get an EB2 in order to get a priority date that is a lot sooner than an EB3. Okay, so when I told you EB2 and EB3, that's 80 to 90% of the employment petitions. EB2, maybe 20% of the bunch. EB3 is sort of the bread and butter. It's the meat. It's where the vast majority, probably 70% of all employment petitions go under EB3. Okay? Now, EB3 is classified as in different areas as well. Okay? The EB3 is divided into skilled workers, professionals, or other workers. Okay? So for an EB3, you have to have at least 2 years experience. Okay, that would go into the skilled worker category. So you have to have at least 2 years of experience, and then you can be petitioned for an EB3. Now, there's different things you have to take into consideration. If you're having a company petition you for an EB3, and they are the same company that you got the experience from, then generally, as a general rule, you can't do the EB3 with them. So there are exceptions. Okay, I mean, one is if you start in one field and you end up in one that's completely different. So if you started a janitor and you move your way up so that, 12 years later you're, marketing analyst, then you can do it. But otherwise, you should have a different company petition you so you can show you got the 2 years experience at a different company than the ones petitioning you. It also has to be normal for the industry, okay, to do that type of work, that to need at least 2 years. So again, I'll use the secretary position. If it's just an entry-level secretary and you're doing nothing other than, saying hello and transferring calls, then you're not going to be able to claim you need 2 years experience on it. They won't believe it. And so you're not realistically going to be able to do at least that section of the EB3. But if it's, for example, a legal secretary that handles all kinds of incoming calls, maybe also does translations, also does calendaring and, all kinds of other stuff, then it's very, very possible that 2 years experience would be the minimum, okay? And there they could be. So that's one area. The other area would be what's referred to as professionals. Those are people who have at least a 4-year bachelor's degree. Okay, so if you have a 4 years bachelor's degree, you will be able to do an EB3. Now, you can't just rely only on that generally. You should have some experience too, but you do not need 2 years experience if you have the 4-year degree. Now, in the EB, I know I'm dividing and saying many different categories. Hopefully you're following me. In the EB3 category, the third part of that would be unskilled workers. So what is that? Well, that is something that does not require a bachelor's degree and does not require 2 years experience. Okay? Anything that falls in that category falls under unskilled worker. So it doesn't have to be like 0 experience. I mean, you might need something that needs, for example, 6 months experience. Okay. If it requires 6-month experience, then, you can do the EB3 and, you'd be able to go on that basis. Now, I'd like to move on then to the EB4. And that really is not an employment-based petition, so I'm going to be very brief with it. It is under, I mean, strangely enough, it's under the employment-based chart, and it, has priority dates and backlogs and things. But the EB4 is divided into different areas, and one of them specifically are VAWA or battered spouse petitions, but another is religious petitions. Okay, that would fall under EB4. So if you're coming in a religious capacity, a real religious capacity, and you have at least 2 years paid experience, then the EB4 would be for you. Okay. And it's actually very nice if you happen to have a church or a mosque or a synagogue petition you, and you are of a religious nature, the EB4 is good to go for you. Okay. And then finally, the EB5. Where I told you before that there's different categories for, each of the employment-based preferences, well, the reality is that for EB5, it's basically just an investment visa. Okay, it can be divided into a couple areas where you either do your own business or you invest in a regional center, but generally that requires about $1 million investment. It requires years of work and waiting and so forth. And there's lots of issues and so forth with the EB5. But if you don't fall under any of the other categories and you have that amount of money and you don't want to do anything else, then the EB5 investment visa would be for you. But remember what I said. If you're going to do the EB5 visa, but you own businesses and you're buying one here, you might want to strongly consider the EB1C. Okay, but you have to keep both businesses open if you do that. Okay, so that in a nutshell, it might not have seemed a nutshell to you, but it is a nutshell, are a description of the categories of employment-based petitions. Now, how does it work? Procedurally, what do you have to do in order to actually get it to happen? Okay, so there's what's known as the PERM, okay, or labor certification, which is a big process, okay? But the purpose of a labor certification, or a PERM, we'll just refer to as PERM, is to show that there's no available U.S. workers for the position. That's the bottom line, okay? You have to show there's no available workers for the position. And that, for the most part, is the starting point of any employment-based petition. Now, when I say for the most part and any, of course, with anything in law, there's exceptions. The entire EB1A category does not require a PERM. There's the EB2 category under certain circumstances with what's called a national interest waiver. The EB4 category does not require it, and the EB5 category does not require it. So why am I going into all this detail about PERM? Well, like I told you, the EB2 and the EB3, on average, is the meat of where most employment petitions go. So if you have 80 to 90% of employment petitions in those categories, you have to do the PERM. Okay, you have to show that there are no available U.S. workers for the position. And that's why when I was telling you that, for example, on the EB3, if you have just a bachelor's degree, you probably need more than that to successfully do a case, because let's say it's computer science. If you put that what is required for this job is a degree in computer science, that job will be gone in 5 seconds with 100 Americans applying for it. So there has to be some other items in addition to the degree that will be necessitated in order to properly do the job. Okay, so that's the first process, would be the PERM. Now, along with the PERM, and actually before the PERM is actually filed, you have to do what is called the prevailing wage request. And the prevailing wage request is when the government determines in the area you are in and the job you're going to do, this is going to be what you should be paid because this is what a normal person with these qualifications will get paid. That's the prevailing wage. And when they come down with that, that's what has to be offered. That's a minimum that has to be offered. Now, there are ways of disputing that, of doing your own, survey on prevailing wages, but those are fairly intensive processes. And if you want to just move along, you'll take what they say. Now let me tell you, there's people who qualify for the EB2, which again is the higher master's degree, but the prevailing wage on an EB2 is quite a bit higher than the prevailing wage on the EB3. So if the company itself either doesn't qualify or have the ability to pay the prevailing wage for an EB2, they will petition an EB3 even though the person qualifies for an EB2, okay? So there are considerations that need to be taken depending on what the prevailing wage would be, all right? Now, let's say that you have the job certified. So what happens is the Department of Labor makes you jump through all these hoops and so forth. And ultimately, if it's approved, you get a certification of the job, okay? And when the perm is certified, you now have legally proven that there are no available U.S. workers for the position. And then you can move on to what's called the I-140 process. The I-140 process has to be done within 6 months of the approval of the labor certification. If you do not, then everything you did and all the waiting you did and the approval was for nothing. So you better get the I-140 in within 180 days. Now, what's the purpose of the I-140? What does that do? Well, now we transfer the focus to the employee, okay, on one basis. We show that the employee has all the qualifications to do the job. We show that the employee is qualified and so forth. I mean, unfortunately, there's people who put through employment-based petitions. They do a perm, they get the perm satisfied, and then when they do the I-140, it's denied because, for example, the person doesn't have the proper degree or can't verify the experience, okay, things like that. So assuming that all goes smooth, that's the I-140. And the I-140, also a very important part of the I-140, is showing the company who's petitioning has the ability to pay. And that's a legal immigration term, ability to pay. Just for example, let's say the job, they make the prevailing wage is $75,000 a year. There better be a net income verifiable by taxes in that particular item. Sorry, there's someone calling. In that particular item that shows that the company has sufficient money in which to do the I-140, okay, in which to pay the employee coming in. And again, I've seen cases where everything goes smoothly. The perm is approved. The person has the necessary information in which to take the job, but the company doesn't have the ability to pay. And they have to have that from the day you file the perm. So they might have it every other year, but they might not be able to show the year that the perm was filed that they had it is going to be denied. Okay, so you need to be careful. That's why I get a lot of clients that call and they'll say, "Hey, I'm starting a business today. Can I petition somebody?" And of course the answer is no, because they have no verifiable way to show that they have ability to pay. Okay, so that's the I-140. And once that's approved, then what happens? Well, if the beneficiary, that's the person who's applying for the job, is inside the US and meets the qualifications, they can now do the third part, which is the adjustment of status. Okay, they can adjust to get their green card to ultimately start working permanently for the company. Okay, and that's where it all goes. Now, and that is the line it takes to go through and do employment-based petitions. Okay, now with this, there are dependents and derivatives that can jump on board. So one person, one spouse, applies and goes through all this employment-based process, and if that person has a spouse, that spouse can jump along and adjust status also. If there are unmarried kids under 21, then they can also jump on board. So that's why in some cases, when I'm doing it, sometimes we can have them come on a non-immigrant visa and we can relax through the perm process and so forth. But if the kids are of such an age that they might age out, meaning over 21 by time the adjustment or consulate processing stage comes, then the kids will have to find their own ways. So if someone has, 2, 3 kids and they're all under 21 and they want the person who wants to be employed wants the green card, if one of the kids is 17 or 18 or 19, depending on what country they're from and what petition, you'll want to rush this through so that they are protected and they get in as a derivative. So the other way that they can do the third phase, if they're not in the US, is through consulate processing. And that is where they take the necessary petitions, it gets transferred over to the necessary consulate. It goes through the various processing, and then from there, they come in with the green card to work for the company that they want to work for. And again, there's the derivatives. If the spouse and children want to come, they can also come. Now, the next question I always get is, well, how long do I have to work for this company? Well, my answer is always the same. You have to intend to work for them permanently, okay? And that means permanently. However, should something happen down the line, should the company not like you, should you not like the company, should things not be what you thought they were, then you are free to go your own way. But you cannot start an employment-based petition, say, okay, I'm going to go through all this stuff and I'm going to get the green card and then 5 days later, I'm going to quit. Or on the 6th month and 1 day, I'm going to quit. Now, if you have a pre-intention to do that, that's not legal and they could begin revocation of your green card. But if you have the intention to work permanently and 6 months later you find, let's say you get a job in San Francisco, you find you hate San Francisco, then you're free to go your own way. That's legitimate. Okay? So that in a nutshell is the employment-based petitions, procedures, and eligibility all in a nutshell. Okay.